In California, filing for divorce means asking the court to legally end a marriage, and it starts with a specific set of forms filed at the county court. There are now two ways to start the process. One spouse can file alone and have the other formally served, which is the traditional path. Or, as of January 1st, 2026, both spouses who already agree can file together on a single joint petition. This video covers both paths: the residency rule that determines whether you can file at all, the starting forms, the filing fee and the fee waiver option, how service works, and what happens once the case is open. Before anything else, California sets a residency requirement for divorce. At least one spouse has to have lived in California for the 6 months right before the case is filed, and in the specific county where it is filed for the 3 months right before that. California's legal term for a divorce case is dissolution of marriage. Divorce is simply the common word for the same thing, and both terms describe the identical court process. Legal separation is a different type of case that does not carry this residency rule, which is one reason some people who have not yet met the divorce residency requirement start with a legal separation case instead. Once residency is met, there are two ways to open a California divorce case. The traditional path is one spouse filing the petition alone. That spouse is called the petitioner, and the other spouse, the respondent, is then formally served with a copy of the petition and has to be given a chance to respond. This path works regardless of whether the spouses agree on everything, nothing, or somewhere in between, because it does not require any action from the respondent to get the case started. It has been the only way to open a California divorce case for decades. The newer path is the joint petition, available for cases filed on or after January 1st, 2026. Instead of one spouse filing and the other being served and responding separately, both spouses file together as co-petitioners on a single form, Form FL 700. This path is only available when both spouses already agree on ending the marriage and are both willing to file jointly. Because both spouses are already parties to the case from the moment it is filed, there is no formal service step between them the way there is on the traditional path. The rest of the process that follows, including the same waiting period and the same court review of the final terms, still applies either way. Which path fits a given couple comes down to whether both spouses are ready to file together right now. Two people who agree on ending the marriage and are comfortable signing and filing jointly can use the new joint petition. Two people where that is not the case, whether because they have not reached full agreement yet or one spouse is not ready to participate, use the traditional path, with one spouse filing first and the other being served afterward. The starting forms depend on which path is used. On the traditional path, the petitioner files Form FL 100, the petition. It asks for the basic facts of the marriage: the date it began, the grounds for ending it, which in California is almost always irreconcilable differences, and what the petitioner is asking the court to eventually decide, including how property and debts should be divided, whether either spouse is asking for support, and if there are children, custody, and parenting time. Alongside the petitioner also files Form FL 110, the summons, which is the document that formally notifies the respondent a case has been filed and states the deadline for responding. If the couple has children together, a third form is required at the start. Form FL 105, the declaration under the Uniform Child Custody Jurisdiction and Enforcement Act, often called the UCCJEA Declaration. It asks where each child has lived for the past 5 years. Courts use this information to confirm that California, and that specific county, actually has the legal authority to make custody decisions for that family, since a child who recently moved from another state can sometimes still fall under that state's jurisdiction for a period of time. On the joint petition path, both spouses file together on Form FL 700, which combines much of what a separately filed petition and response would otherwise cover. If the couple has children, the same UCCJEA declaration, Form FL 105, is still required alongside it. Virdix asks about your marriage, your children, and your county in plain language, and fills out these starting forms from your answers, for either the traditional path or the joint petition. Filing the initial petition requires a filing fee paid directly to the county superior court. The fee is $435 in most California counties, and a few counties charge slightly more, up to about $450, because of local courthouse surcharges. This fee applies whether the case is opened on the traditional path or the joint petition path. For anyone who cannot afford the filing fee, California allows it to be waived. Form FW001, the request to waive court fees, lets a person ask the court to excuse the fee based on already receiving certain public benefits, having a household income under a level tied to the federal poverty guidelines, or another documented financial hardship. The qualifying benefits include programs like Medi-Cal, CalFresh, SSI, CalWorks, General Assistance, and several others listed right on the form, and the income limit is printed on the form as well, based on household size. The court reviews the request and decides whether to grant it. Filing the form does not waive the fee automatically. Virdix has a free tool that gives you a read on whether you may qualify for a fee waiver. Using the same public benefits and household income questions the court's own form asks, before pointing you to Form FW001 itself to file. It is not a determination, only the court decides. On the traditional path, once the petition is filed, the respondent has to be formally served with a copy of it and the summons. California does not allow the petitioner to hand the papers to the respondent directly. Service has to be carried out by someone else, a person over 18 who is not part of the case, a professional process server, or the county sheriff. Whoever serves the papers then signs a proof of service, filed with the court, confirming when and how service happened. Once served, the respondent generally has 30 days to file a response, Form FL120. If no response is filed, the case can still move forward through a default process, though the details of that process go beyond this video. On the joint petition path, there is no separate service step between the spouses, since both of them are already parties to the case from the moment they file it together. After the case is open, both spouses exchange financial information through a disclosure process, and then, if there is anything left to work out, they negotiate directly or the court holds hearings to resolve property, support, and custody. Separately from any of that, California requires a waiting period. A judgment cannot be entered until at least 6 months have passed from the date the respondent was served or first appeared in the case, whichever happened first. That waiting period applies even when both spouses agree on every term well before the 6 months are up. Once every issue is resolved and the waiting period has passed, the case ends with a judgment, the court's final order that legally ends the marriage and sets out the terms both spouses are required to follow going forward. Virdix lays out this whole process, start to finish, based on the answers you give about your own case, so you can see each step ahead of time rather than encountering it as it comes up. Virdix is a document preparation service, not a law firm, and this is not legal advice. But whether you are on the traditional path or the new joint petition, it turns the starting forms into a guided process built from your own answers. You can find it at virdix.co.